brother down with Shizzywhiznut.
An open letter to Laura Owens and attorney Gingras. When spin meets felony, the Laura Owens Delusion, Esquire edition. Dear Laura, and most especially you, attorney of the year in your own delusions, Mr. Gideon S. Gingras, you've done it. You've actually outdone yourselves. Just when I thought we'd reach peak absurdity with Laura's podcast policing, TED Talk tear-jerking, chicken soup sob fishing, and people are tracking my every movement paranoia, here comes a verified petition for special action, so performative, so constitutionally confused, so nakedly desperate, it deserves to be carved into marble and displayed in the courthouse lobby under the plaque that reads, "Warning, not how law works." And let's be clear. This wasn't written for the Court of Appeals. No. This was drafted with the intention of success. This was drafted for a performance, a press release in waiting, a future talking point on some soft-lit YouTube interviews where Laura can once again flutter her eyelashes and claim she was denied due process by a biased court, while holding up a document that, if any had more empty legal calories, could be served with Cool Whip and a side of tears. This verified petition for special action, let me pause to appreciate the choice of verified, because nothing screams, I swear, this isn't a tantrum, like slapping that word on a Word document. This is a 30-plus page homage to every kitchen sink legal cliche the internet has ever birthed. You took what is essentially you being mad about losing a family court and tried to spin it into constitutional emergency. A landmark violation of sacred rights and a cinematic injustice so egregious that only the appellate court could restore the balance of the universe. Petitioner alleges a lower court error. Translation, the judge ruled against me and I didn't like it. The commissioner acted illegal, arbitrarily, and capriciously. Translation, I don't understand the ruling. I assume the corruption must be involved. Fundamental rights were violated. Translation, I googled constitutional bug words and duct taped them to my whining. You didn't file a special action. You filed a judicial Yelp review. But this time, she brought back up, Gingras, you actual legal mosquito. Let's start with you, Counselor Gingras. I'm going to use the term counselor very loosely here if we use that word without offending actual lawyers. Moonlights as paralegal at a discount tarot shop. The drafting style suggests someone took a paralegal certification course via Groupon and then asked ChatGPT badly to make it sound urgent but fancy. Well, because this filing reads less like the work of a licensed professional, more like the third semester moot court dropout trying to impress his parole officer. You wrote a petition dripping with constitutional theater and zero legal substance. Every page screams, I read part of a con law textbook once and now I think I'm Clarence Thomas, if Clarence Thomas had a Tumblr blog and a drawer full of adult coloring books. You throw around terms like arbitrary and capricious, violations of equal protection, and in excess of jurisdiction like confetti at a pity party. But here's the thing, words mean things, and in a courtroom those things have to be backed up with actual law and facts, not the fever dreams of a client who thinks she's the main character in a true crime docuseries. You can't just spray it on like Axe body spray and hope the court swoons. And that whole in excess of jurisdiction thing, honey, unless Commissioner Spencer grabbed the gavel, kicked in the courtroom door and started ruling on maritime law, you're going to need more than a thesaurus and a righteous indignation. Do you genuinely believe the filing met the bar, or did you think the word verified was a cheat code? Well, this is not verified, this is valorized. It's you and Laura standing on the deck of the Titanic with a keyboard and shouting, iceberg unfair. And Laura's fantasy and Gingras' ink, and let's unpack what you two tried to do here. You took a run-of-the-mill family court loss, a ruling you didn't like, and tried to dress it up as a constitutional apocalypse. You framed Commissioner Spencer as some rogue judge who denied Laura her fundamental rights because she followed procedure and ruled based on evidence. You claimed that Laura's rights were violated because the court dared to hold her accountable for filing a paternity case and then abandoning it mid-scandal after she miscarried but still wanted to retain control of the narrative and the defendant. All of this hinges on the idea that feelings equals legal harm, that if Laura feels wronged, there must have been due process violation, that if people on Reddit are saying mean things, then the court must have enabled her harassment. If Clayton Eckerd talks about a public case, well, lock him up and hand her a Pulitzer. It's the legal equivalent of crying fire in a courtroom because someone burned your ego. You lost. You filed a case, tried to drop it, played PR victim while dragging the court through your emotional landfill. And when things didn't go your way, you ran to a higher court with your hands in the air like an injured soccer player begging for a yellow card. You even managed to accuse a judge of bias without a shred of actual evidence, unless you count she didn't agree with me as evidence. You do, you clearly do. And rather than accept that you were held to the same legal standard as anyone else, you've decided that you, Laura Owens, curator of the TED Talk temper tantrum, mother of the misunderstood miscarriage case, patron saint of the restraining order misuse, were targeted by a grand conspiracy of judicial injustice. Well, it's laughable. And sad. And laughable again. Mostly laughable. Special action, more like special effects. The special action is supposed to be reserved for extraordinary relief, not for clients who want to run a judicial GoFundMe campaign to litigate their public humiliation. And humiliation seems to be her kink. This petition isn't an appeal. It's a press release with footnotes. And your extraordinary circumstance seems to be my client made a mess of everything, blamed the judge, and now wants a do-over without paying the piper. Other words, she wished she hadn't swallowed. Laura Owens misused in a court process and got called on it. She tried to control the media fallout by painting herself a persecuted truth teller. Now she's hiding beyond your keyboard like it's a riot shield. But Gideon, baby, if this is your shield, it's made of wet cardboard and borrowed outrage. I love how I call him Gideon. Let's talk about the commissioner you smeared. The real gall here, that really gets me, is how you too casually assassinate Commissioner Barbara Spencer's character in this filing. You don't prove misconduct. You don't show evidence of bias. You just simply imply it over and over again like it's a TikTok trend and hope the Court of Appeals won't notice that your entire case rests on a fact that your client didn't get her ever-loving way. She ruled, you lost, that it's not a violation of due process. That's called Wednesday in courtrooms across America. You made this snake pit, and let's not forget Laura's own role in manufacturing the very scandal she now wants judicially erased. She filed the paternity case, went public with it through TED Talks, social media, and sympathetic interviews, attempted to drop the case, but still publicly commented on it, accused others of stalking, harassment, and worse, with zero criminal charges to support her. Then had the gall to claim that she was the one being silenced. Gingras, if you think this is the kind of constitutional violation that the appellate court should entertain, then I suggest you look up the phrase frivolous filing and start prepping your own motion for sanctions, because this is not just embarrassing, it's borderline unethical. You claim you were maternally harmed? That's cute. Was your TED Talk canceled? Did your chicken soup for the soul stop returning your emails, or was this just another chapter in your performance art series, How to Weaponize the Legal System While Playing the Victim of Soft Lighting? You keep referencing rights, due process, equal protection, the Constitution, like you're defending a whistleblower on a war tribunal, and you're not. You're complaining that a judge ruled on your case using evidence instead of vibes, and now you're flinging legal spaghetti at the appellate wall, hoping one soggy strand sticks long enough to give you one more chance at TikTok relevance. Well, the final verdict is this. The petition is toilet paper manifesto. It's a legal tantrum, a shameless attempt to paint Laura as the hero of a story that she set on fire, a cosplay of the constitutional law written by a man who ought to know better but clearly chose not to. You didn't write this file to win, you filed this to whine. So here's my suggestion. Take this verified petition, roll it up, store it next to Laura's TED Talk DVD and a box of unsold chicken soup anthologies, because that's all this document is worth. Comfort food for delusion, written in legalese and delivered to a court that will no doubt see through it faster than Laura switches narratives. This isn't a special edition, it's a special delusion, a desperation filing dressed up in constitutional drag, complete with emotionally charged nonsense and passive-aggressive footnotes. You didn't file a petition, you wrote a manifesto for people who think court rulings are popularity contests. And to the nameless hack who helped draft it, if this is your idea of persuasive legal writing, please do us all a favor and pursue a less harmful career path like flavor text writer for expired salad dressing labels. Sincerely, Shizzywhiznut. First of his name, courtroom clown wrangler, still smarter than this filing with a helmet on backwards and mittens clipped to his jacket.
It is about time. Let's break this mother down. With Shizzywhiznut.